Hello, this is Professor Scott Applegate. Welcome to PSCS 6248 Introduction to Cyber Conflict. This is Unit 2, Lesson 1, Cyber Conflict and the Law of Armed Conflict. Agenda. In this lesson, we will discuss the law of armed conflict and how it applies to the cyber conflict domain. We will review the major tenets of international humanitarian law, such as jus ad bellum and jus in bello. We will briefly review the Tallinn Manual and international views on the law of armed conflict as it applies to cyber conflict. We will explore several treaty models that have been proposed as models for regulating cyber conflict. We will explore the unique challenges posed by non-state actors in this domain. And finally, we will review the responsibilities that states have to prevent cyber attacks that originate from within their borders. Introduction. At a recent conference of legal experts in Washington, D.C., Professor Michael Schmidt, probably the foremost expert on the application of the law of armed conflict as it applies to cyberspace operations, stated that the international community was largely in agreement that the law of armed conflict, also known as international humanitarian law, does apply to cyberspace operations and conflict activities that occur in and through cyberspace. Where there is a lack of consensus is on how and where the law applies. This is because nation-states harbor different opinions on what the role of cyberspace operations should be, what actions constitute a use of force in cyberspace, and how military actions will be conducted going forward. It is important to remember that we are at the fledgling stages of military operations in cyberspace. We often compare the current state of cyber conflict to the dawn of military aviation. We are about the same stage as military aviation was prior to World War I, where pilots were throwing grenades out the windows of biplanes. An additional challenge is that much of what happens in this domain is done through covert or clandestine means and is often classified or unattributed. The law of armed conflict. So what is the law of armed conflict or international humanitarian law? International humanitarian law is the law that regulates the conduct of engaging in war or armed conflict, jus ad bellum, and the conduct of forces when they engage in war or conflict, jus in bello. This includes crimes against peace and war of aggression. It is that branch of international law which seeks to limit the effects of armed conflict by protecting persons who are not participating in hostilities and by restricting and regulating the means and methods of warfare available to combatants. It includes the Geneva Conventions and the Hague Conventions, as well as subsequent treaties, case law, and customary international law. It defines the conduct and responsibilities of belligerent nations, neutral nations, and individuals engaged in warfare in relation to each other and to protected persons, usually meaning non-combatants. It is designed to balance humanitarian concerns and military necessity, and subjects warfare to the rule of law by limiting its destructive effects and mitigating human suffering. The law of armed conflict does not specifically address cyber incidents, attacks, or warfare since it was written before the advent of the Internet. This leads to questions as to whether the law of armed conflict applies to cyber warfare and can cyber attacks constitute a use of force under international law. Most legal scholars would answer yes to both of these questions. It is important to keep in mind that international humanitarian law was largely created to prevent violence between nation-states. It was written after some of the worst wars the world had ever seen, and it concerns itself with stopping or preventing violence at the state level. International humanitarian law states that no state or group of states has the right to intervene, directly or indirectly, for any reason whatever in the internal or external affairs of any other state. Consequently, armed intervention and all other forms of interference or attempted threats against the personality of the state or against its political, economic, and cultural elements are in violation of international law. Over the next few slides, we will define several key terms that are important in understanding how international law describes violence and unlawful activity between states. As we explore these terms, try to determine what actions in cyberspace would fall within the boundaries of these concepts. Aggression. Aggression is defined as the use of force by a state against the sovereignty, territorial integrity, or the political independence of another state, or in any other manner inconsistent with the Charter of the United Nations. The Charter of the United Nations does not really define what armed force means. This is something we typically have to try to determine on our own. Some good questions to ask are, does a cyber attack meet these criteria? In other words, does a cyber attack or can a cyber attack threaten the sovereignty, territorial integrity, or political independence of another state? If the answer is yes, then a cyber attack could be considered an act of aggression. Attack is defined as an act of violence against the adversary, whether in offense or defense. What is an act of violence? International humanitarian law does not actually define this. Use of force. Article 2, subsection 4 does not use the term war, but rather refers to the threat or use of force. Although clearly encompassed in the article, it is ambiguous whether the article only refers to military force, or if it encompasses economic, political, ideological, or psychological force. Most scholars assume Article 2, subsection 4 only refers to military force based on the original intent of international humanitarian law to prevent violence between states. International humanitarian law is divided into two main bodies: jus ad bellum, the right to wage war, and jus in bello, the conduct of forces during war or conflict. Jus ad bellum is characterized by 5 foundational tenets: right authority, right intention, probability of success, last resort, and proportionality. Jus in bello is characterized by 6 foundational tenets: military necessity, distinction, proportionality, benevolent quarantine for prisoners of war, mala in se, and no reprisals. We will explore these tenets in the following slides. Jus ad bellum. Jus ad bellum refers to the conditions under which states may resort to war or the use of force against other states in general. The United Nations Charter of 1945 sets out only 2 exceptions under which a state may legally employ the use of force against another state. These exceptions are self-defense, to include anticipatory self-defense, and actions authorized by the United Nations Security Council. The tenet of right authority refers to the legal authority that allows a state to engage in the use of force against another state. As noted earlier, these authorities would include self-defense and United Nations Security Council actions. It is important to note that the use of force does not encompass other unfriendly actions such as espionage, boycotts, economic embargoes, or other actions that fall below the threshold of force. Right intention refers to the way a state may employ the use of force in relation to a just cause. In the event that an action in cyberspace rises to the level of a use of force, it must meet the criteria noted for both these tenets to be considered legal under international humanitarian law. Jus ad bellum also dictates that force should only be used as a last resort and only if there is a reasonable chance for success. There are numerous ways in which cyber operations could be used below the level of a use of force that would actually complement the tenet of last resort. Making use of malicious cyber activity in lieu of resorting to an armed attack would be fully in keeping with the spirit and letter of international law. Nation-states should not attempt to use force against another state if there is not some probability of success in the endeavor. Force should be used judiciously and not haphazardly or in futility. Finally, a state should not undertake war if the cost of waging such a war outweighs the benefits to be gained. Extra care must be taken when considering actions in cyberspace, as second and third order effects may not be entirely predictable in this relatively new domain of conflict. United Nations Article 2, subparagraph 4 and Articles 39 and 51 provide the framework for the legal use of force under international law. Article 2, subparagraph 4 states all members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state or in any other manner inconsistent with the purposes of the United Nations. There are two exceptions: the United Nations Security Council actions and self-defense, as laid out in Articles 39 and 51, which we will discuss in the following slides. The first exception against the prohibition of the use of force is United Nations Security Council actions. This is based on Article 39 of the UN Charter and amplified in Articles 41 and 42. Article 39 states that the Security Council shall determine the existence of any threat to the peace, breach of the peace, or act of aggression, and shall make recommendations or decide what measures shall be taken in accordance with Articles 41, try to employ measures not involving the use of force, and 42, United Nations Security Council sanctioned use of force if Article 41 provisions fail, to maintain and restore international peace and security. Article 41 states the Security Council may decide what measures not involving the use of armed force are to be employed to give effect to its decisions, and it may call upon the members of the United Nations to apply such measures. These may include complete or partial interruption of economic relations, of the rail, sea, air, postal, telegraphic, radio, or other means of communication, and the severance of diplomatic relations. Article 42 states that should the Security Council consider that measures provided for in Article 41 would be inadequate or have proved to be inadequate, it may take such action by air, sea, or land forces as may be necessary to maintain or restore international peace and security. Such actions may include demonstrations, blockade, or other operations by air, sea, or land forces of the members of the United Nations. Article 51 provides a section exception to the strictures laid out in Article 2, subparagraph 4. Article 51 states that nothing in the present Charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a member of the United Nations, until the Security Council has taken measures necessary to maintain international peace and security. Measures taken by members in the exercise of this right of self-defense shall be immediately reported to the Security Council and shall not in any way affect the authority and responsibility of the Security Council under the present Charter to take at any time such actions as it deems necessary in order to maintain and restore international peace and security. Cyber attacks under jus ad bellum. Difficulty in attribution and uncertainty about what constitutes a use of force in cyberspace have hampered the application of international humanitarian law to cyberspace operations. However, there is general consensus among nation-states and legal scholars that international humanitarian law does apply to cyberspace operations and cyber attacks. Efforts like the Tallinn Manual are helping to clarify opinion and codify the application of existing law to this new domain. One of the key issues that has received a great deal of attention in recent years is what constitutes a use of force in cyberspace. Numerous models have been suggested in how to approach this problem. We will explore three possible approaches to determining whether a cyber attack qualifies as a use of force. These are the instrument-based, strict liability, and effects-based approaches. In the instrument-based approach, the effects of a cyber attack are compared to the effects of traditional kinetic attacks. If such attacks could previously only have been caused by kinetic weapons, then the cyber attack would likely be considered a use of force. This would generally include effects such as physical damage, injury, or death. This approach is probably the most palatable in the international community, as it is the easiest to explain under current international law. The strict liability approach names certain acts, such as attacks on critical infrastructure, as a use of force, regardless of the resulting effect. This approach would be more difficult to justify in some cases, as what one nation would call a use of force would be debated by other states and might prove too subjective. It would also most likely require amendment to current international law to be enforceable. The effects-based approach looks at the overall effect of a cyber attack on the nation-state regardless of its similarity to traditional kinetic attacks. So if a state manages to cripple another state's economic systems through the use of a cyber attack, this could be considered a use of force regardless of the lack of physical damage or injuries because of its potentially devastating effect on the overall economic health of the state. Again, this approach would be difficult to justify in some cases, as what one nation would call a use of force would be debated by other states and might prove too subjective. It would also most likely require amendment to current international law to be enforceable. One example of an effects-based approach was created by Professor Michael Schmidt, one of the leading experts on cyber conflict and international law. Professor Schmidt's approach evaluated cyber attacks based on 6 criteria: severity, immediacy, directness, invasiveness, measurability, and presumptive legitimacy. The chart provides a graphic example laying out cyber attacks and evaluating them in terms of overall effect. A higher score on the chart corresponds to the likelihood of an attack being construed as a use of force. This model is just provided as an example, and we will not explore it to great depth. Severity looks at the scope and intensity of an attack. Analysis under this criteria examines the number of people killed, size of the area attacked, and amount of property damage done. The greater the damage, the more powerful the argument becomes for treating the cyber attack as an armed attack. Immediacy looks at the duration of a cyber attack as well as other timing factors. Analysis under this criteria examines the amount of time the cyber attack lasted and the duration of time that the effects were felt. The longer the duration and effects of an attack, the stronger the argument that it was an armed attack. Directness looks at the harm caused. If the attack was the proximate cause of the harm, it strengthens the argument that the cyber attack was an armed attack. If the harm was caused in full or in part by other parallel attacks, the weaker the argument that the cyber attack was an armed attack. Invasiveness looks at the locus of the attack. An invasive attack is one that physically crosses state borders or electronically crosses borders and causes harm within the victim state. The more invasive the cyber attack, the more it looks like an armed attack. Measurability tries to quantify the damage done by the cyber attack. Quantifiable harm is generally treated more seriously in the international community. The more a state can quantify the harm done to it, the more the cyber attack looks like an armed attack. Speculative harm generally makes a weak case that a cyber attack was an armed attack. Presumptive legitimacy focuses on state practice and the accepted norms of behavior in the international community. Actions may gain legitimacy under the law when the international community accepts certain behavior as legitimate. The less a cyber attack looks like an accepted state practice, the stronger the argument that it is an illegal use of force or an armed attack. These criteria, although somewhat subjective, provide an interesting model to frame the problem. Jus in bello. Jus in bello is the portion of international humanitarian law that regulates the conduct of forces engaged in armed conflict. The rules of jus in bello aim to confine the destructiveness of war, rule out certain kinds of weapons, protect civilians, and limit the area and range of fighting. Jus in bello is characterized by 6 foundational tenets which we will discuss over the next few slides and attempt to explore how these tenets apply to the use of cyber operations in a conflict. The tenets of military necessity and distinction specify what types of targets that armed forces can or should engage. Whenever possible, armed force should not be directed at non-combatants or neutral parties. Unfortunately, in war, it is not always possible to avoid civilian casualties. In these cases, actions must be intended to help defeat the enemy. Direct or collateral damage to civilians must not be excessive and must occur in relation to anticipated military advantages. The use of cyber weapons is very problematic under the concepts of military necessity and distinction. The majority of the internet is owned and operated by civilian organizations. Cyber weapons almost always must, at the least, transit civilian, neutral, or third-party networks to reach their intended targets. In the 2003 U.S. invasion of Iraq, the United States wanted to fly over a number of countries to reach northern Iraq. Some of these countries turned down the United States' request, which caused the U.S. to reroute its flights around these countries. One could legitimately presume a similar precedent in cyberspace. Additionally, with the sometimes unpredictable nature of cyber weapons, there is a high likelihood that these weapons will affect third-party, civilian, or neutral systems. The Stuxnet attack against Iran, which was designed to be very specific in its targeting, infected more than 200,000 computers worldwide. The benevolent quarantine for prisoners of war will likely have little relevance in cyberspace operations due to the remote nature of these operations. The tenet of proportionality deals with what kind of force is morally permissible in warfare. It suggests that the injury caused should be proportional to the objective desired, and that the extent and violence of warfare must be tempered to minimize destruction and casualties. Cyber weapons, by their nature, may spread to non-combatants or neutral parties. Effects of cyber attacks can be difficult to predict, detect, assess, or quantify. This implies that cyber weapons must be employed with great care given the potential for these weapons to spread to unintended systems and create unplanned second and third order effects. The tenet of mala in se states that combatants should not use weapons or methods which are evil in and of themselves. An example of this type of warfare would be the Nanking Massacre during the Second Sino-Japanese War in 1937, during which mass murder and mass rape were committed by the occupying Japanese troops. Nuclear and chemical weapons also fall under this tenet. Cyber weapons, at least in their current incarnation, would probably not fall under the auspices of mala in se. However, development of kinetic cyber weapons could potentially cross this line in the future depending on their effects. The tenet of no reprisals dictates that even if the enemy does not or refuses to adhere to the principles or conditions of jus in bello, there should be no retaliation in the sense of violating or refusing to adhere to jus in bello. In other words, two wrongs do not make a right. This is not just to prevent a spiral effect, but also due to a concern for humaneness. The Tallinn Manual. The Tallinn Manual is an academic, non-binding study on the application of international humanitarian law to cyber warfare by a renowned group of legal scholars. The original Tallinn Manual focused solely on operations in cyberspace during an armed conflict. A second edition has recently been published, which broadens its focus to include cyberspace operations outside of and below the level of armed conflict. In other words, it covers activities in the so-called gray zone. It is important to understand that although the Tallinn Manual represents the opinions of some of the preeminent legal scholars in the field, it is not law. It is a recommendation on the application of current international law to cyberspace operations and cyber warfare. The Tallinn Manual Major Findings. Overall, both Tallinn manuals concurred that international humanitarian law does apply to cyberspace operations and affirm that just as they do in other domains, states have a right to exercise self-defense in response to attacks that rise to the level of a use of force. This applies both in the case of state-sponsored or non-state-sponsored attacks. Additionally, the Tallinn manual affirms that cyber operations alone, conducted by one state against another state, can be sufficient to create an international armed conflict depending on the effects created by the attack. Such a conflict need not involve the employment of the armed forces. Cyber operations are subject to the same geographical limitations imposed by international law applicable during an armed conflict as you would have in the physical domains. States cannot conduct attacks on the infrastructure of neutral nations, nor can they create attacks from a neutral nation. A neutral state cannot knowingly allow a belligerent state to conduct cyber attacks from infrastructure located within its territory. Doing so would invalidate its stance of neutrality and draw it into the conflict as a belligerent state. Cyber operations that create effects similar to those in a kinetic armed attack would constitute a use of force under international law. The Department of Defense Law of War Manual reaches a similar position, stating, if cyber operations cause effects that, if caused by traditional means, would be regarded as a use of force under jus in bello, then such cyber operations would likely be regarded as a use of force. The manual offers as examples cyber operations that trigger a nuclear meltdown, open a dam above a populated area causing destruction, or disable air traffic control systems resulting in airplane crashes. To the extent an illegal use of force in the cyber domain were to occur, whether perpetrated by a state or non-state actor, the victim state could lawfully exercise its inherent right of self-defense and respond with proportional military force. The Tallinn manual also noted that attacks that interfere with the functioning of equipment, which cause the replacement of that equipment, does not qualify as damage. Cyber attacks against data, which result in kinetic effects in the geophysical world, can be considered an armed attack depending on the effects. A cyber operation that does not result in some degree of damage in the geophysical world, even if it results in large-scale adverse consequences, does not constitute an armed attack. However, a cyber operation can still constitute an armed attack even if the intended destruction does not occur. So if an actor attempted to create a cyberkinetic attack and that attack failed, resulting in no damage in the geophysical world, the mere attempt could still qualify as an armed attack. Cyberspace operations that do not rise to the level of a use of force or an armed attack are generally not prohibited by international humanitarian law. This would include operations that specifically target civilian populations, for example, psychological operations. This also includes cyber espionage. The Tallinn Manual upholds the concept that a commander bears ultimate responsibility for the actions of his or her unit, noting that commanders and other superiors are criminally responsible for ordering cyberspace operations that would constitute a war crime. Just as it applies in the physical domains, a commander conducting operations in cyberspace may not employ indiscriminate means of warfare. Means should be directed at specific military objectives and should limit collateral damage to civilian objects to only those necessary to achieve military objectives and only when the benefits outweigh the potential damages. International views on the law of armed conflict. China. China's views on the law of armed conflict and cyberspace operations are currently in flux. At the time of the writings of both the course textbooks, China was very reluctant to agree that the law of armed conflict applied to cyberspace operations. This was primarily attributed to China's concern about operations they were engaging in and the desire to continue the use of those operations to their advantage. A series of public disclosures over the last few years, along with bilateral negotiations with the United States, appear to have created an evolution in Chinese views on the subject. In 2015, China and the United States conducted bilateral meetings in which the two nations agreed that certain actions, such as the theft of intellectual property, were outside the emerging norms of cyberspace. Additionally, both nations affirmed that the law of armed conflict does apply to activities in cyberspace. Most of the actions China currently engages in and through cyberspace would not fall under the auspices of international humanitarian law, since they do not represent uses of force. So this change in view did not materially affect the majority of China's operations. The Netherlands is a strong proponent of international law and affirms that international humanitarian law is fully applicable to hostilities in which the belligerents use cyber weapons and techniques. The Netherlands Constitution actually requires the country to promote international law and treaties, and they were strongly involved in the drafting and review of the Second Tallinn Manual. The Netherlands do not believe that additional treaties or amendments to current international law are necessary, as they believe that current international law is sufficient to encompass cyberspace operations and warfare. They do acknowledge that applying the law of armed conflict to cyberspace operations that are not carried out in conjunction with conventional forms of warfare can be more complicated, and they have drawn a distinction between attacks that do or do not rise to the level of a use of force. Overall, the Dutch affirmed that the applicability of the law of armed conflict to cyberspace operations is technically feasible and legally necessary. Publicly, Russia has stated that its armed forces are guided by the regulations of international humanitarian law. The Russian Federation introduced a draft resolution in the First Committee of the UN General Assembly in 1998, making information security a UN agenda item. It was adopted without a vote and was the predecessor to the efforts by the government group of experts. Russia publicly advocated for limitations on the indiscriminate use of information weapons and prohibition of treacherous methods of waging information warfare. Simultaneously, Russia is one of the most aggressive state actors using cyberspace operations today. Russia has purportedly used cyberspace operations against other states, including Estonia, the Ukraine, and the United States, and Russia has used cyberspace operations in conjunction with kinetic operations in Georgia. While Russia has been aggressive in this domain, all of the incidents attributed to Russia thus far have fallen below the level of a use of force, implying they are exercising care to stay in the gray areas not subject to the law of armed conflict. While the United Kingdom's cyber strategy does not explicitly mention the law of armed conflict, Britain has publicly affirmed that all governments must act proportionately in cyberspace and in accordance with national and international law. Like Russia and the United States, Britain appears to have an extensive and aggressive cyberspace operations program. The UK is consistently listed as one of the most capable nation-states working in this domain. The UK has stated that it is committed to working with other countries on practical confidence-building measures to reduce the risk of escalation and avoid misunderstandings. The United States has affirmed that U.S. forces will conduct cyberspace operations consistent with its policy principles and legal regimes to include international humanitarian law. The United States has consistently been an advocate of the law of armed conflict in its kinetic operations, and it is therefore likely it will apply the same level of restraint in the cyber domain. In harmony with the United Nations affirmation of a state's right to self-defense, the United States has noted that it reserves the right to respond in self-defense using all elements of national power. The U.S. has publicly stated that it will respond to significant cyber attacks and has suggested that significant means having an impact analogous to kinetic effects seen in traditional hostilities. While the U.S. has affirmed the application of international humanitarian law to offensive cyberspace operations, it has also noted that other factors, such as domestic policy and rules of engagement, may apply to its decisions. Potentially useful treaty models. While there is general consensus that international humanitarian law applies to cyber conflict, there are currently no international treaties or agreements that specifically cover this domain. Several existing treaty regimes have been suggested as models to develop a treaty regime governing cyber conflict. The most prevalent of these models include nuclear nonproliferation, the Antarctic Treaty System or Space Law, the United Nations Convention on the Law of the Sea, and mutual legal assistance treaties. None of these models would appear to be ideal, as we will see in the following slides. The Treaty on Non-Proliferation of Nuclear Weapons came into force in 1970, and as of 2016, there are 191 states which adhere to its provisions. This treaty's objective is to prevent the spread of nuclear weapons and weapons technology, and has been generally successful because components for building nuclear devices are highly restricted and closely monitored. This model is unlikely to work for cyber conflict, as the components for cyber operations and warfare are already widely distributed and are comparatively inexpensive. It is also nearly impossible to regulate the spread of these technologies, since they can be easily transported across the Internet buried in common Internet traffic. The Antarctic Treaty and related agreements came into force in 1961 and regulate international relations with respect to Antarctica, Earth's only continent without a native human population. Space law encompasses national and international law governing activities in outer space. The Declaration of Legal Principles governing the activities of states in the exploration and uses of outer space came into force in 1963. These treaty regimes largely rely on the inaccessibility of Antarctica and space and the ease of monitoring access to these areas. These models will also be difficult to apply to cyber conflict, since access to cyberspace is trivial and it is nearly impossible to easily differentiate between peaceful and malicious code, especially when you consider security software. Maritime law dates back to the 17th century and defines the rights and responsibilities of nations with respect to their use of the world's oceans. The United Nations Convention on the Law of the Sea took place between 1973 and 1982. UNCLOS treats international waters as a global commons. However, attempts to apply this description to cyberspace is likely to result in contention between states with differing viewpoints. You have to remember that every device on the internet physically resides within the sovereign territory of a nation-state, so the analogy to the sea is not entirely accurate. Several states have already begun to assert their sovereignty over their portions of the internet and are thus unlikely to agree with this model. Mutual legal assistance treaties, also known as MLATs, are catch-alls for individual cooperation agreements between nation-states. While these types of agreements are promising, it is worth keeping in mind that these types of agreements only apply to the signatory states and cannot be used to force provisions onto non-signatory states. In recent years, the Russian Federation has favored the establishment of non-proliferation measures in regards to cyber conflict. They argue that politically motivated cyber attacks should be dealt with through domestic law enforcement when committed by non-state actors, and that those ordered by states can be qualified as military crimes. Given the Russian trend of using proxy actors, this type of regulation would tend to favor their doctrinal use of cyberspace. The United States has demonstrated a preference for enforcement of existing domestic and international laws and has focused primarily on mutual legal assistance treaties to address cyberspace activities. Challenges posed by non-state actors. Historically, non-state actors have participated in conflicts. Active participation by these groups will generally draw them into the conflict as illegal combatants. The terrorist attacks of September 11, 2001 set several new precedents in regards to non-state actors. UN Resolutions 1368 and 1373 paved the way for the U.S. invasion of Afghanistan in 2001. These resolutions allow states to respond with force when attacks by non-state actors were imputable to a state and the state bears some responsibility for these actions. Resolution 1373 imposed specific conditions on states to criminalize terrorist actions and potentially allowed for other states to take action if and when such states did not take actions to prevent or prosecute terrorists taking refuge within their borders. Non-state actors have the potential to lose their civilian status through direct participation in hostilities. Acts amounting to direct participation in hostilities must meet three cumulative requirements. 1. The act must be likely to adversely affect the military operations or military capacity of a party to an armed conflict. 2. There must be a direct causal link between the act and the harm or the expected harm. And 3. The act must be specifically designed to directly cause the required threshold of harm in support of a party to the conflict and to the detriment of another. These requirements could potentially be applicable to non-state actors participating in cyber attacks and could confer illegal combatant status on the actors in question. This means they would be legal targets, but they would not be afforded the legal protections of the Geneva Conventions conferred on armed forces legally participating in an armed conflict. States' responsibility to prevent cyber attacks. Do states have to act to try to prevent cyber attacks that originate from within their borders? International law does imply that, similar to preventing attacks in the geophysical world, states must act reasonably to prevent cyber attacks as well. UN Resolution 1373 does not specifically discuss cyber attacks, but it implies that states have an affirmative duty to prevent cyber attacks from their territory against other states. Any toleration of such attacks constitutes a crime under international law. This duty actually encompasses several smaller duties to prevent cyber attacks, including passing stringent criminal laws, conducting vigorous law enforcement investigations, prosecuting attackers, and cooperating with the victim states of cyber attacks during the investigation and prosecution, just as they would for kinetic attacks. These are the duties of all states and are binding as customary international law. The authority for these duties comes from all three sources of customary international law: international conventions, international custom, and the general principles of law common to civilized nations. The attacks of September 11, 2001 shifted the state responsibility from direct control to indirect responsibility. UN Resolution 1368, which reaffirmed the United States' inherent right to self-defense after the 9/11 terrorist attacks, in accordance with Article 51, allowed the U.S. to apply the self-defense exception to an attack by non-state actors. Afghanistan's failure to fulfill its international duty to prevent non-state actors from using its territory to attack other states served as justification for the use of force. Such a precedent could potentially be applied in the cyberspace domain as well. This does not mean that a state failing to prevent a cyber attack from within its borders is imputable for this attack. It means that should a cyber attack occur and the harboring state not cooperate with the international community to find and prosecute the non-state actors involved, they could then be held to some level of responsibility. While a state may be held responsible for harboring non-state actors or failing in their duties to the international community, the victim state must still take into account jus and bello concepts of necessity and proportionality in any response they take. They must evaluate whether the host state implemented reasonable measures to prevent attacks from within its territories. Just because an attack comes from within a state does not automatically make it guilty of violating international law. Cyber attacks are extremely difficult to prevent, but the host state must provide a reasonable level of cooperation in response to such an event. Cyber war or not? There have been many events described as cyber war over the last 2 decades. The question is, are any of these events a cyber war? The first and obvious answer is no. There's no such thing as a cyber war. There is war. There can be a war that involves attacks in the cyberspace domain, but that is not a cyber war. So we must reframe this question. Have we seen acts in cyberspace that rise to the level of a use of force? In almost all cases, the answer is still no. The only possible exception to that might be the Stuxnet attack. In this case, we have a cyber attack that caused physical damage and targeted critical infrastructure systems. One could make a legitimate argument that Stuxnet represented a use of force. Summary. Cyber conflict poses a difficult challenge under international law, but by and large, states are in consensus that international humanitarian law applies to cyber conflict. While there are no formal treaty agreements between nation-states regarding cyber attacks or cyber warfare, many states believe the current legal framework is sufficient. A number of models have been proposed as alternative means to deal with cyber conflict, but most of these are problematic in implementation. Finally, the vast majority of what have been called cyber attacks do not rise to the level of a use of force under the law of armed conflict, and would therefore not be governed by this legal framework.